Hello, my name is Benjamin Hart. I'm an American attorney and the managing director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing plenary power and immigration law. I thought of making this video after reading a recent comment on our channel, quoting directly, "Great advice has always been, but one has to pose the question. If you don't have a definitive answer, then neither do they, question mark. What I'm trying to say is if they forgot to dictate an actual limit, then surely you would be pulled over and issued with a warning, but allowed in rather than denied. Also, in absence of an actual limit, is there any right of appeal? After all, no quote-unquote law has been broken, question mark." Okay, so what they're talking about here is I did a video on is there a limit to the number of Thai tourist visas one can get? And my response there was, there is insofar as whatever the Thai embassy abroad or immigration authorities decide at a checkpoint coming in. And this commenter, what they're getting confused with is there is a law. It's called the Immigration Act of 1979. And under that law, Thai immigration officers are vested with a great deal of discretion associated with undertaking the enforcement of Thai immigration law. And what people don't really get about that is that very much entails what's called plenary power oftentimes in the jurisprudence of the United States. And plenary power in the context of U.S. immigration, I would argue is basically the same thing at the end of the day, but it's a little more parsed out in terms of the jurisprudence out there associated with U.S. immigration law because we've had court cases and things that have gone up to the Supremes and discussed it. And so we've got a little bit more, how do I put it, a little bit more explanation on the difference. The way I look at plenary power, if you will, it sort of sits in this nebulous world sort of between legal power, sovereignty. It's kind of where, in a sense, you could argue it's where legality and sovereignty meet. I don't think that's quite right. It's its own thing. Plenary power comes about because there are just certain functions that the state needs to perform. And in the case of immigration, that's a function that's been deemed oftentimes as an essential function to essentially the survival of the state. If a place is overrun by people that aren't from that location, that given jurisdiction, like literally physically overrun, it can result in essentially the end of that polity, the end of that government, the end of that system, the end of that civilization, if you will, the end of that society. And plenary power is vested in immigration officers. Yeah, and that's the same in the United States too, for that matter. But here in Thailand, yeah, the way I look at it, again, sort of as an outside observer, although I've been all through all the various channels of Thai immigration, if you will, personally, and we've assisted people here at the firm many different times. But this whole thing of there's no law. Yeah, there's a law. There's the Immigration Act of 1979, which empowers Thai immigration officers to make adjudications as to whether or not somebody is fit for entry to Thailand. There's also the same authority or similar authority is granted to officers at embassies and consulates abroad who have to adjudicate whether or not it's appropriate to issue a visa. So yeah, there's a law, and they clearly have the discretion. The officers, the aforementioned officers, have the discretion to either issue visas, issue status in Thailand, grant lawful status to enter Thailand in visa status. And yeah, that's again, it's based on the Immigration Act of 1979, but beyond even that, there's plenary power that essentially grants discretion to these officers to make their determinations on a case-by-case basis.